Alrighty, folks, we are going to go ahead and get started today. Welcome to Legal Aid of North Carolina's free clinic on wills, powers of attorney, and healthcare's powers of attorney. At today's clinic, you will learn what you can do now to ensure that your wishes are carried out when you pass away. You will also learn what you can do if you need someone to act on your behalf now or in the event you become incapacitated at a future date. The clinic will explain the different types of documents that allow you to plan for your future and the effect of the COVID-19 emergency on your ability to prepare and execute these documents. Our presenter today is Meredith Gregory, a supervising attorney with Legal Aid of North Carolina's Senior Law Project. She grew up in North Carolina and attended UNC Chapel Hill for her undergraduate studies. She attended law school at Syracuse University's College of Law, where she graduated magna cum laude and was a member of the Law Review. After law school, she clerked for a family court judge in Jersey City, New Jersey. She came to work for Legal Aid of North Carolina in 2007 and has worked for the Boone, Silva, and Asheville offices of Legal Aid. In 2012, she came to the Senior Law Project, which is a division of Legal Aid serving clients age 60 and over. She currently resides in Asheville. At the end of the presentation, you'll have the opportunity to ask questions to the attorney through the webinar. If you're on Zoom, there is a Q&A feature that you can use. You can also post your questions in the chat, and we will hold those for the attorney at the end. If you have joined us on Facebook today, you can post your question as a comment there. And again, we will hold those for the attorney at the end of the presentation. Please keep your questions as general as possible, as we are unable to answer questions specific to the facts of your case. After the webinar today, if you still need assistance, you can call the Legal Aid Helpline at 866-219-5262 for a financial screening. If you qualify for our services, you can speak with an attorney about your specific situation. Legal aid services are free of charge. If you are 60 years or older, you may also call the Legal Aid Senior Law Helpline at 877-579-7562. Thank you for attending today's clinic. And with that, I will turn it over to you, attorney Meredith Gregory. Are you there?
Yes. Can you hear me, Blaine?
We can hear you. You're coming through just fine.
Okay, great. And can you see me now?
Yep.
Okay, great. So good afternoon, everyone. And Blaine, thank you for that introduction. As Blaine let you all know, I'm going to be talking to you this afternoon about end-of-life planning documents like wills and powers of attorney, and in particular, how this pandemic has affected those documents. All right, so here's kind of a little outline of what I'm going to be talking about today. I'm going to do a quick introduction, and then I'm going to be talking about the common end-of-life planning documents. And then I will be talking about the execution requirements, which you can also think of as the signing requirements for these documents. And then I'm going to be talking about changes to the execution of these documents that have happened due to the COVID-19 pandemic. Okay, so Blaine already gave you an introduction for me, but my name is Meredith Gregory, and I'm a supervising attorney with the Senior Law Project, which is a division of legal aid serving people 60 and over, serving senior citizens. And I've been with Legal Aid about 13 years, and I've been with the Senior Law Project since 2012 for about 8 years. So first of all, a few caveats before I start my presentation. I'm only going to be giving very general information about these documents and how they work and how they're executed. I can't give any specific legal advice about your specific situation. Also, it's important to understand that I'm talking about North Carolina law only. I'm an attorney licensed in North Carolina. So if you're watching from another state, the laws of your state may be different. Okay, so first of all, what is Legal Aid of North Carolina? We are a statewide nonprofit law firm that provides free legal services in civil matters to low-income people in order to ensure access to justice and remove legal barriers to economic opportunity. So that's our mission statement. But what does that mean? What exactly do we do? So here's some examples of some common types of cases that legal aid might handle, that we handle very often. We get domestic violence protective orders for victims of domestic violence. We help tenants fight evictions, We help people keep public benefits like food stamps and Medicaid. We help homeowners going through foreclosure, and we work with debtors who are facing illegal debt collection. And here's really quick how you could possibly apply for our services if you think legal aid can help you. You don't need to jot that down right this second. I will have this slide up again at the end of my presentation, but you can also always find our contact information on our Facebook page and on our website. And I also encourage you just to go to our website and learn a little bit more about what we do and how you can apply for services and that sort of thing, which is legalaidnc.org. Okay, so moving on to talking about the actual end-of-life planning documents. You might also hear these documents called estate planning documents, and often attorneys who handle these documents call themselves estate planning attorneys. Means the same thing. So there are four major end-of-life planning documents that I'm going to be talking about today. The first one is the will. The second is a financial power of attorney. The third is a healthcare power of attorney. And the last document is a living will. So why do you need these documents? Why would you want to get end-of-life planning documents? Well, they can be very helpful to your loved ones if something should happen to you so that you're not able to handle your financial affairs anymore. It enables your family members to help you out without having to go to court and get a guardianship. It also makes sure that things happen the way you want them to at the end of your life and even after you pass away. It can help make sure that your wishes are carried out. So the first document that I'm going to be talking about is a will. And most people kind of have some idea of what a will is and what a will does. But in case you don't know, it is a legal document that sets out who will inherit your assets after you pass away and who is to manage those assets before they're and until they're passed on to your heirs. So basically it says who gets your stuff. And it names someone to kind of handle the paperwork and do all that sort of thing to make sure those people do in fact get your stuff. So when does a will take effect? This is really important to understand. A will has no meaning and no effect until the day you pass away. So you could literally change your will every single day of your life as long as you are still mentally competent. And the only will that the courts would follow would be the last one that you signed before you pass away. Another thing that's important to understand is that the person you name as your executor, who, like I said, is the person who kind of takes care of the paperwork and handles things, has no authority to act on your behalf until you pass away. So for example, the person you name to be your executor can't call up your bank and say, you know, I need to know how much money mom has in her bank account, or mom needs new checks or something like that. That person has no authority to act on your behalf unless and until you pass away. So what happens if you die without a will? There's a lot of confusion out there surrounding this. If you die without a will, your property does not go to the state. It does not go to the state of North Carolina. Your assets will pass by a specific set of North Carolina laws called the laws of intestacy. Wills are sometimes called testaments. So if you die intestate, that means you die without a will. So the laws governing if you die without a will are called laws of intestacy. And what those laws say, very basically, this is very oversimplified, but basically those laws say that your assets go to your closest family members. Now, what exactly that means for you and who exactly would inherit from you according to the laws of intestacy depends on a lot of different factors like the makeup of your family, whether you're married, how your assets are titled, whose names are on the deeds to your property, how those deeds are written, that sort of thing. So speak to an attorney if you want to know your specific situation. But in general, it will be your closest family members. I think lots of times the reason people think that their property goes to the state if they don't have a will is because they're getting that situation mixed up with what happens if they pass away owing money to Medicaid. So if Medicaid pays for long-term care for you, so in other words, if you have to go into a nursing home and Medicaid has to pay for that, which it does for most people unless you're very wealthy, once you pass away, Medicaid can sometimes attempt to go after your property. This has nothing to do with whether or not you have a will. It's a separate issue. Again, this is very much an oversimplification. Medicaid estate planning is very, very complex, even for attorneys. So again, speak to an attorney about your specific situation. But I think maybe some people here, you know, my friend who I went to church with, when she died, the state took her house, and so they assume that's because of a lack of a will, but it's a different situation. Okay, so dealing with minor children and disabled adults in a will. Now, you can, in your will, if you have guardianship or custody over a minor child or a disabled adult, within your will, you can suggest someone to become the guardian of that child or the disabled adult. This is technically not binding on a court. It would, of course, be very, very persuasive to a judge, especially if you are a biological parent or a lifelong guardian to a person. It would be very, very persuasive. It's not technically binding. So in other words, you can imagine a situation where, you know, say I have a minor child and I, in my will, I name my brother I suggest my brother to be the guardian of that minor child. Well, if in between the time of when I write the will and when I pass away, my brother, who is a very right now hardworking, responsible person, if he takes a turn for the worst and develops a substance abuse problem and ends up, you know, homeless and not able to take care of himself, a court is not going to say, oh, well, you know, Ms. Gregory said her brother should be guardian, so we're stuck with that. No, a court would always look at the best interests of the child in deciding who should have custody or guardianship of the child. Now, if my brother remains a very hardworking and responsible person, the fact that I've suggested him is going to be very, very persuasive to a judge. So it's not as if that means nothing. It's just not completely binding. So I also wanted to talk about the issue of standby guardianship. I did have a couple of folks ask about this when I did my last presentation like this. So standby guardianship is where you name where you're a guardian of a disabled adult and a minor child, and you want to name someone who can step up and immediately be guardian of the minor child as soon as you pass away. You can't establish standby guardianship in a will alone. It requires a petition in front of the clerk. It cannot be done in the will. And it requires that the parent or guardian have a fatal or progressive chronic illness. So it's when you know that you're a parent, you're very sick, you have a fatal illness, you're expected to pass away, you can petition the clerk to set up a standby guardianship. So it's really only available in pretty limited set of circumstances. Okay, so the next document that we're going to talk about is the financial power of attorney. And just FYI, most of the time when people just use the term power of attorney, the one that they mean is the power of attorney for financial matters, because this was the document that existed first. So it used to be when people were talking about power of attorney, that was the only one. So normally when people just use that phrase, they're talking about the financial one. So a financial power of attorney is a document that names someone to help you out in financial matters. So the person that you name to help you is technically called your agent. Lots of times you'll hear people use the term power of attorney or POA for abbreviation to talk about the actual person. And that's fine. Most of the time people will know what you're talking about, but technically the person acting on your behalf is the agent, and the document itself is called the power of attorney. So some examples of things that your agent under a power of attorney could do for you: he or she could write checks on your behalf from your bank account. He could transfer money from your savings account to your checking account, call your car insurance company, call the county tax office and ask if your real estate taxes are paid up. So those sort of financial matters, financial transactions. So when does a power of attorney take effect? If you are executing a power of attorney, you get to choose. You can either have your power of attorney take effect right away. So in other words, the day you sign it, your agent could then take it to your bank and ask about your account balance or that sort of thing. Or you can make it only take effect in the event of some future event, like if you become incapacitated and you can't handle your affairs yourself. So some people might say, you know, I really want my daughter to be able to help me out with my bank account if something happens to me and I don't have a good mind anymore, but I really don't want her up in my business right away. So I'm going to execute a power of attorney today, but it's only going to take effect if and when I become incapacitated, when I can't make these decisions and I can't understand these things myself. And that is a good option in that situation. So limits on your agent under a power of attorney. So even though your agent under a power of attorney is given access through the power of attorney to your finances, that agent must use the money in a way that benefits you and you only. So for example, even though your agent might be able to write checks from your bank account, she should not be writing checks to pay her own cell phone bill. She should only be writing those checks to pay your bills and in a way that benefits you. However, it is very important to understand that just because that's what the law says, it doesn't mean, just because the law says the agent can only use the principal's finances in a way to benefit the principal, it doesn't mean that agents never act wrongfully. So executing a financial power of attorney creates a huge potential for financial abuse and exploitation. And we see this at the Senior Law Project all the time. It gives someone access to your money. So you want to be very, very careful in who you pick to be your agent if you do execute a power of attorney, because that person would be essentially given the ability to use your money, and it can be really challenging to get that money back once it's gone. So you want to choose very wisely. The difference between a power of attorney and guardianship. So it's very important to understand that executing a power of attorney in and of itself does not take away any of your own decision-making authority. Signing a power of attorney does not make your agent your boss. It doesn't put the agent in charge of you. Doing that requires guardianship. So in order for someone's own financial decision-making power to be taken away, they have to go to court and be declared legally incompetent and have a guardian appointed. And this requires a court decision. And lots of times people think, oh, you know, I want to buy a new car or I want to do this thing, but my power of attorney won't let me. Technically, that's not really correct under the law. You are still in charge of your own finances. Your agent becomes essentially your helper. So an example that I like to use to explain this is I went to law school in New York State, but the bank I use is State Employees Credit Union, which obviously doesn't have offices in New York. So I made my dad my agent under a power of attorney so that if anyone needed to go to the bank for me in person, he can go and sign my name, that sort of thing. He only used the power of attorney document a couple times. I've never revoked it. It's technically still in effect, but I, of course, am an adult and I am in charge of how I spend my money and what I do with my money. My dad is not all of a sudden in charge of my finances just because I executed a power of attorney, 15 years ago. Okay, so the third document that we're going to be talking about is a healthcare power of attorney. A healthcare power of attorney is a document that names someone to make your medical and healthcare decisions if you are no longer able to make those decisions yourself. So for example, if you had executed a healthcare power of attorney and then all of a sudden you have a car accident unexpectedly and you're unconscious and in a coma, your healthcare agent could step in and make those decisions like, should we have the surgery right away, or there are these risks, should we wait, that sort of thing. Those are the types of decisions your healthcare agent could make on your behalf. So some other examples of the types of decisions that your healthcare agent could make. Your healthcare agent can consent to surgery, that your agent could decide whether to enter a nursing home, whether to leave a nursing home, whether to change the dosage of your medicines, whether to request old medical records. Basically, any medical decision that you could make for yourself, your healthcare agent could make on your behalf, unless you place specific limitations in the healthcare power of attorney document. And you do have the option to do that within the document. So what is the difference between a healthcare power of attorney and a financial power of attorney? A financial power of attorney allows your agent to help you out in financial matters. The healthcare power of attorney enables your agent to help you out in healthcare and medical matters. And if you only sign one of these documents, then your agent is not going to have authority to act in the other arena. So for example, if you only sign a healthcare power of attorney, that healthcare power of attorney agent is not going to be able to go to your bank and ask what the balance is in your bank account, or write checks on your behalf, or call your car insurance company, or that sort of thing. You would need it to have a financial power of attorney in order for your agent to do those things. So when does a healthcare power of attorney take effect? If you remember, I said that you have some choice in the financial power of attorney. Do you want it to take effect right away, or only if you become incapacitated? Unlike the financial power of attorney, the healthcare power of attorney only takes effect if and when you are no longer able to make your medical decisions yourself. So as long as you still have capacity and you're able to understand medical and healthcare decisions, your doctors are always going to go to you and only you. So you don't have really the same way to execute a healthcare power of attorney and make that person your decision maker right away. So the last document that we're going to talk about is a living will. And this is a document that tells your doctors that if you're getting toward the end of your life, if you're very, very sick, then you don't want what we call extraordinary life prolonging measures. So for example, you might sign a living will that says, if I'm expected to die very soon, if I'm not expected to recover, I don't want to be put on a ventilator. You will also hear this document called an advance directive for a natural death, or sometimes just shortened to an advance directive, because it's giving a directive in advance for what you want to happen regarding your end of life care. What is the difference between a healthcare power of attorney and a living will? A healthcare power of attorney names someone else to make your medical decisions for you if you can't make them yourself. A living will expresses your own wishes for end-of-life care. Now, there is very often quite a bit of overlap in these two documents. In other words, they will apply and go into effect at the exact same time. Say if you're in a car accident all of a sudden and you get very, very sick very quickly. But there's not always perfect overlap. An example of that is sometimes people have dementia for many, many years, and they might for 4, 5, 6, 7, 8 years, they might lack capacity to make their own healthcare decisions, like should they increase their medicine, should they reduce their medicine, should they change their diet, you know, those sort of healthcare decisions, but they're not really at those end-of-life decisions like should mom be put on life support type of thing. So there can often be overlap, but there's not necessarily perfect overlap, which is why it's a good idea to have both a healthcare power of attorney and a living will if you end up in that situation where you're incapacitated for many years but aren't at the end of life decision point yet. Hope that makes sense. Okay, what is the difference between a living will and a DNR? We often have clients contacting us at the Senior Law Project asking for a DNR. A DNR stands for a do not resuscitate order. And this is a medical order that comes from a doctor. This is something your doctor signs and puts in your chart or whatever. A living will is a legal document that you execute yourself, probably, maybe not, with the help of a lawyer. So a lawyer cannot give you a medical DNR order. You have to get that from your doctor. So when does a living will take effect? Within the living will document, you have a few different choices as to what will trigger the living will, but it's generally when you're very, very sick, you're not expected to live very long, you're not expected to recover, that sort of situation. So what is needed for these documents to be valid? So in order for these documents to be valid and enforceable, they must be executed in a formal way. And executed is a term of art that lawyers use to mean it was signed by, a document was signed by the maker of the document, so you and possibly others, in a way that's set out by statute. So it means formalities of how it's written up and how it's signed in a way that will make the document valid and enforceable by the North Carolina courts. So these documents, in order for them to have legal effect, in order for them to be followed by the courts of North Carolina, they have to be written up and signed in a specific way. And you just having those intentions, you just wanting certain things and just writing them out without following the formalities, it's probably going to end up with documents that won't be enforced by the court. So, for example, if you have a neighbor that you love like a sister and is closer to you than your family, so you want your neighbor to inherit all your property after you pass away, you can't just write your neighbor an email and say, hey, Janice, hey, Gladys, I want you to get everything when I pass away. That email is not going to be valid and enforceable. Your neighbor, Janice, is not going to be able to take that email to the courts after you pass away and have it enforced. That email is not going to transfer title to your house, your car, your assets. Okay. And similarly, and this is similar to a situation that I had with a client that was actually really, really sad, where a grandfather owned a big farm, a lot of acreage, a lot of land. He had lots of children, lots of grandchildren, and one of his granddaughters was his closest grandchild and always helped him out on the farm and did all the mowing and the tractor work and things like that. And at one point, grandpa had taken this granddaughter and driven her all around the farm and said, you know, sweetie, one day this will all be yours one day. So she had understood that to mean I inherit this property. So when grandpa passed away, she assumed the farm was hers. So she paid all the expenses, did all the upkeep, paid the taxes on it year after year, and assumed she owned it. Well, grandpa never executed a will. So him just saying this will all be yours one day does not transfer title to his property. So when he died without a will, it actually legally passed to a whole bunch of people, not just this one woman. And it was, you know, a very sad situation for her to learn that she didn't actually own this property. So basically, executed means signed in a formal way by the maker and other people. So there has recently been a change to these laws based on the COVID-19 pandemic. The laws as to what needs to happen for these documents to be valid and enforceable has just changed as of May 4th, 2020. So literally just a few days ago. And this change to the law just went into effect May 4th. And right now the new laws are set to last until August 1st of 2020, or the end of North Carolina's declaration of an emergency, unless this statute is extended by the legislature, which it might be. So before this, so the reason I'm telling you that now is so that you know that these requirements that I'm telling you now are not the law right now. They were before May 4th, and they most likely will be after August 1st. But right now, these are outdated requirements. So the old requirements were, in order for these documents to be valid, most of the documents, 3 out of the 4 documents, had to be signed by the maker of the documents, by you, if you're the person writing a will. They had to be signed by you. They had to be signed by 2 witnesses who both had to be disinterested witnesses, and they had to be signed by a notary. Now, the power of attorney document does not require the 2 witnesses. It only requires that the document be signed by the maker of the document and a notary. So this meant, before May 4th of 2020, this meant that 4 people had to be in the room together to do these documents. The maker of the documents, 2 witnesses, and a notary. So that was 4 people all in the same room together. And they were, before May 4th, they were required to literally physically be close to one another. Notarizing a document, the statute that sets out the requirements for notaries said that the notary had to be in close physical proximity to the signer of the document. So as you can imagine, these 4 people all in a room together, close to one another, created a huge issue when people were trying to socially distance and within this pandemic. So this new set of laws that just went into effect about 3 weeks ago allows notarization by video technology. So that means things like Zoom, like you may be using right now, or any kind of application that allows video conferencing with people. So the requirements under this new law for notarization by video conference technology has its own set of requirements. So both the principal, the maker of the document, must be in North Carolina. They don't have to be close to one another. They don't have to be in close physical proximity. One could be in Asheville, one could be in Wilmington, but they do both have to be in North Carolina. They also have to be able to be using some kind of video conferencing technology that allows them to hear one another clearly, and they must be able to interact in real time. So things like a telephone or taking a video and emailing it to someone, that is not sufficient. They have to be able to interact, ask each other questions. They have to be able to both hear and see each other clearly. And the notary must watch the principal sign the document using the video conference technology. There's also been a change to the witnessing requirement. People who need to witness documents. So if you remember, I said 3 of these 4 documents before May 4th required 2 witnesses, and those witnesses had to be in the same room with the maker. Well, now, according to these new laws, the witnesses can also witness by video technology, Zoom, that sort of thing. These witnesses must also be in North Carolina, and the video conference technology must allow for real-time interaction, just like the notary. The witnesses and the principal, meaning the maker of the document, also must be able to hear and see each other. It also allows the witnesses to sign one page of a document and mail it or carry it in person to the part that the maker signed and combine all those counterparts into one original document. Another change, and this is a pretty big deal, before May 4th, as I said, 3 of these 4 documents needed 2 witnesses as well as the notary. The will, healthcare power of attorney, and living will all needed 2 witnesses in addition to the notary. Well, with this new set of laws, the healthcare power of attorney and the living will do not need 2 witnesses. Those only need to be signed by the maker of the document and a notary. So now, with these new laws in effect, only one of these documents, the will, needs the 2 witnesses. So the financial power of attorney, the healthcare power of attorney, and the living will need only be signed by the maker of the documents and the notary. So I hope you were able to follow all that. I know it was a little bit confusing. So I did this little summary page to help you follow that. From May 4th until August 1st, the will needs to be signed by the principal, the maker of the document, 2 witnesses, and a notary. But the power of attorney, the healthcare power of attorney, and the living will need to only be signed by the principal and the notary. And that can be done by video conferencing technology. So really, those 3 documents especially are fairly easy to get executed properly right now. It just takes 2 people and they can use video conference technology. So if you don't have access to video conferencing technology, which hopefully most of you who are watching this, you must be watching this some way. So you at least have access to the internet and can download Zoom. But if you have elderly relatives, or not necessarily elderly relatives, friends who don't have access to the internet and that sort of thing, you can still try to get these documents executed. Some attorneys are still doing these documents. A lot of attorneys aren't because of the risks involved. Some attorneys are. And before these changes to the law went into effect, the Secretary of State, which is the state agency that governs notaries, did make some suggestions as to how to get these documents executed and still follow social distancing. So she did have some suggestions. She suggested that all parties could be in one room, but you could try to find a larger room. So do like a conference room instead of your small office, and have everyone stay 6 feet apart. She suggested having people separated by things like tables, plexiglass, those sheets of plastic that look like shower curtains, like you might see at the grocery store, that sort of thing. Another thing that I've heard that some private attorneys were doing were having the people executing the documents would stay in their car. So they might just roll down the window a little bit and sign the document and then pass it through the window. Kind of like what you're seeing with a lot of the COVID-19 testing, where people are staying in the cars. Lawyers were having these documents executed that same way. She also suggested that all parties wear personal protective equipment like masks and gloves, and not to share pens. So have the makers, the people executing the documents, either bring their own pens or have the attorney, give the clients pens and not get the pens back, just let them keep the pens, that kind of thing. So some attorneys may be following those practices. So how is legal aid handling this? Because the Senior Law Project does execute these documents for people. It's actually quite a large part of our practice. At this very moment, we are not executing these documents with clients at all. We put a hold on executing these documents around the middle to the end of March to kind of see how things play out. And the reason we paused these doing these documents at all, there were a few different reasons. For one thing, we serve a lot of rural areas, and the way that we're able to serve these areas is, even if our office is maybe an hour and a half, 2 hours away from a rural area we're serving, we go to the local senior centers and we have what we call will clinics, where we sit in one office and we literally meet with clients one after the other all day long, 8 or 9 clients in one day at a senior center. And one of the reasons we stopped doing these documents is that these senior centers are closed right now. So a lot of the rural counties where we were serving, we didn't really have a way to serve them. And also with us meeting with clients one after the other, one client leaves, another one walks back in. We were figuring out the best way to do this safely. So we are going to start now that these new laws have gone into effect, we are working on setting up our protocol to do these documents by video conferencing. So we are hoping to start doing that as of June 1st. So hopefully soon we will start executing these documents by video conferencing. So I also wanted to talk really quickly about handwritten wills. We did have a lot of people asking about that, and I did think it was especially important to mention, especially for this, before these new laws went into effect, allowing the execution of these documents by video conferencing. Technically, handwritten wills in North Carolina can be valid and enforceable. The technical name for these types of wills are holographic wills. Now, even though these technically can be enforceable, I really urge you and implore you to only do this if you're not able to meet with an attorney. If it's absolutely impossible for you to go get a will executed, this could possibly be a temporary stopgap solution. I gave the example, this is sort of like if you're camping in the wilderness in the middle of the Smokies and you fall and you break your leg and you build a splint with like a stick and a torn up t-shirt. This is not something that is the end of the line. That's something that you do to get yourself through an emergency until you can get back to civilization and meet with a doctor in person. I would say that handwriting your own will should be that same sort of emergency stopgap solution. And you should absolutely go to an attorney to have a will prepared just as soon as it is feasible for you to do so. Wills are very easy to mess up. It's very easy to not do everything you're supposed to do or write it in a way that can be confusing and can end up causing more problems than you were trying to solve. So I highly recommend to speak to an attorney to have a will executed properly with an attorney. But if you do want that emergency stopgap solution, these are the requirements for a valid handwritten will. First of all, the document has to be entirely in your handwriting. So not where you write up what you want your will to say and type it up and print it out and sign the bottom. It has to be entirely in your handwriting. It has to be signed by you. It has to be found in a proper place with your important papers, in a place that you would use to store your important papers. In a safety deposit box, has to be in some other place where you keep important papers, or with someone to whom you've given the will specifically for safekeeping. After you pass away, when your executor presents the handwritten will for probate, the executor will have to produce 3 witnesses to the fact that the will was written in your handwriting. So that itself can be somewhat challenging in this day and age where we email and text all the time and don't even really write that many handwritten notes anymore. So there have to be 3 witnesses to testify that, yes, this is your handwriting. And there has to be 1 witness to testify that, yes, this document was found with the testator's important papers. And the testator is the person who wrote the will. Okay, so that's basically the end of my presentation. I did want to put up really quickly again how to apply for legal aid services. You can apply online through our website at legalaidnc.org. You can call what we at the Senior Law Project call our regular helpline, so the helpline for people of all ages, which is 1-866-219-LANCE. Or if you're age 60 years or over, you can call our senior helpline, which is part of the Senior Law Project, the division of legal aid that I work for. And that telephone number is there as well. All right, so now is the time when we can take questions.
All right, so we've got a couple questions that have already come in. If you do still have questions, feel free to go ahead and, if you're on Zoom, put them into that Q&A. Or if you have joined us on Facebook, you can put a comment on the live event and I can get them from there. So we will start with the ones we've already got. If a financial power of attorney has co-agents, a son and daughter, will both children have to sign checks, do things together, that kind of thing?
The way powers of attorney are normally written is that you name first one agent and then you name an alternate agent. So most of the time, like for example, if you say, I want my daughter to be my agent and the alternate agent is my son, most of the time the person you name first acts as the agent and only that person acts as the agent. You can set it up to have co-agents. We generally don't, we normally don't recommend that. It can cause a lot of problems. And normally those agents can act separately. So one agent can act without the permission or participation of another agent. You can write the power of attorney to say that both agents have to work together. That can, for obvious reasons, be very inconvenient. You know, if these are working people or if they live in separate areas and if they both have to get to the bank at the same time on the same day, you know, that can obviously be very inconvenient. Sometimes people think, sometimes people do that specifically to avoid any kind of financial abuse or exploitation. So I do think in some situations, it can be the right choice to require people to have to act together. It can create a lot of confusion. It can create difficulties if 2 people are acting on behalf of one person and they're not communicating or they're disagreeing and one's doing one thing and the next day the other agent is going and undoing it. I mean, it can cause problems. But so the answer is it can be either way, depending on the way the financial power of attorney is written.
Okay. If I execute healthcare directives, does my healthcare power of attorney have to follow those directives?
If you write limitations in the healthcare power of attorney, your healthcare agent is bound by those limitations. So like, for example, sometimes I've had clients who've executed healthcare powers of attorney, and they've said, for religious reasons, I don't believe in blood transfusion, so I don't want my healthcare agent to be able to consent to a blood transfusion. So in that, if you write a healthcare power of attorney with limitations, then yes, they are bound by those limitations. As far as if the living will and the healthcare power of attorney conflict, so in other words, say you execute a living will that says, I don't want to be put on a ventilator if I'm very sick and I'm expected to die and not get better, but your healthcare agent says, I can't do it, I'm not ready to let mama go, I want everything done to extend her life as long as possible. In that situation, when there's conflict, you can choose which you want your doctors to follow. So there's a section in the living will document where it says, if there's conflict between the healthcare agent and the living will, which do you want the doctors to follow? So you have the choice there, which I think is a great thing that people, can do that.
Do the documents need to be redone after August 1st, 2020?
No, that's a very good question. The requirements, assuming that the statute is not extended past August 1st and the statute does expire on August 1st, documents that are executed according to the law before August 1st are still valid. They do have to be written in a certain way that says they're executed according to, 10B dash whatever it is, the statute. But yes, they will still be valid after August 1st.
Okay. Does the notary have to see the witnesses sign the documents via video technology?
And this would only, again, the witnesses are only required for the execution of the will, but yes, the notary would have to see everyone sign just for the will, because the healthcare power of attorney and the living will until August 1st do not require two witnesses.
And I assume for the other ones that don't require witnesses, the notary would still have to be able to see the signing process, essentially.
Yes, the notary has to, for the documents that only require the signature of the principal, the notary has to see, and the principal is the maker of the documents, the notary has to see the principal sign. Okay. But that's only for the will right now before August 1st.
All righty. Does the power of attorney need to be recorded?
The power of attorney can be recorded. It only has to be recorded if the agent wants to carry out real estate transactions. Before 2018, the law said that a power of attorney had to be recorded in order for the agent to act after the principal became incapacitated. As of 2018, the law changed, and the power of attorney only needs to be recorded if the agent wants to carry out real estate transactions. So take out a mortgage on your home, sell your home, transfer your home, that sort of thing. It's not necessarily a bad idea to go ahead and record the power of attorney, but if you do record a power of attorney and then you later want to revoke it, it has to be revoked in a special way, and that revocation also has to be recorded. So it makes it a little, not super hard, but a little bit harder to revoke. So it's just something to keep in mind that, and it does just sort of make it public record. Not that that's a bad thing, but some people don't necessarily want it known in public record that they have a power of attorney.
All right. If you have filed a living will at the hospital previously, is it difficult to rescind and file a new one?
No, you can revoke these documents at any time as long as you are still competent. Technically, you can just tear up the original and that will revoke the documents. The problem with that is obviously if you just tear up the original, that does not let your doctors know that you're revoking that. So you should talk to your doctors and let them know that you want the document revoked. They may just take your word for it. I know banks, if you've given a copy of your financial power of attorney to banks, they usually want to see a physical revocation and see a copy of it before they will honor the revocation, even if it's you saying, I don't want you doing what my power of attorney says anymore. So it's probably a good idea to do some kind of written revocation.
All right, if you are someone's financial power of attorney, are you held responsible for their debts upon their passing?
You are not financially responsible for their debt. So in other words, you don't have to pay their debts. Now you do have obligations to spend their money in a way that benefits them. So in that sense, you have an obligation to pay their debts with their money, but no, you do not have any kind of obligation to use your money to pay their debts. Now, what you do want to be, so that's what the law says. But what you want to be super, super careful of is signing anything that says differently. So if you're putting your mom in assisted living, or you're putting your mom in a nursing home, or you're signing a mortgage on your mom's behalf and you're the financial agent, you want to make sure that you sign as power of attorney. So if your mom is named Josephine Smith and your name is Linda Smith, you would want to sign it Josephine Smith by Linda Smith, power of attorney, or you would want to sign it Linda Smith as power of attorney for Josephine Smith, or something like that. You want to make sure you don't sign your own name, and you don't sign your own name in your personal capacity. So, I can make myself obligated on any person's debts if I sign a contract that says so. I'm not liable to pay my neighbor's medical bills, but if I go to the doctor's office and I sign a contract that says I'll pay my neighbor's medical bills, I can make myself obligated. So you just want to be very, very careful in how you sign documents. Sign the principal's name by your name as power of attorney, if that makes sense.
Is there a website to find these documents and forms as templates in order to print?
These documents are available on the Secretary of State's website, which is, I believe it's sosnc.gov. And they have all kinds of information about these documents, but you do still need to get them notarized. So just remember that you would need to find some way to get them notarized. And they're meant for non-attorneys, and they're written, honestly, for legal documents, the way they're written is fairly straightforward, but there is a lot of information there, and it does take a while to just kind of digest all the information. So I would read them a few times. I would read them very slowly. And the documents that are on the Secretary of State's website are the living will and the healthcare power of attorney. You're not going to find a template for a will, and I don't believe you'll find a template for a financial power of attorney on the Secretary of State's website. But the two healthcare ones, the healthcare power of attorney and the living will, you will. But I would just read them really slowly. Maybe don't plan to sign them and notarize them the first day you read them a few times. And the different paragraphs give you lots of different choices. And on some of the choices, you have to pick one and only one. In some, you can pick several. So just, if you're going to do these documents on your own, read them very carefully and take a lot of time with it.
Alrighty. Will you repeat the statement that needs to be included in a will that is needed to make the will legal during this change due to the pandemic?
There's not one single statement. The change to wills, due to the pandemic is that they can be notarized via Zoom or video conferencing, and they can be witnessed by video conferencing. And there has to be a statement in there that says that it was notarized according to the provisions of the emergency notarization statute. But I'm not really in a place to recite all those requirements.
Sorry, I couldn't unmute myself. What section will they be under on the Secretary of State website?
It is a little hard to find them. You just kind of have to search around. I believe there is one. I know if you, I think there's a.
I think I may have found it, but it looks, do they charge for them?
They do charge. So you can record the documents with the Secretary of State, which kind of like what I was saying with recording the power of attorney, it has its benefits, it has its risks, in that if you change these documents, then you want to make sure you, and I believe they charge $10 per document to record it, but I don't think they charge just for the forms.
Okay, I'm going to try sharing my screen real quick so I can make sure I'm on the right, the page on the website, and then I can post the link for people. So if you would just verify this for me. This looks like I'm in the right place. Advanced healthcare directives on the Secretary of State website. Yeah, and then if you scroll down, there's a healthcare power of attorney, there's a living will, there's a couple of different things here. And it does look like you can open them without any charge, and then you can fill it out.
Yeah, I think
from here.
Yeah, I think you can open them without any charge, and then the charge is to record them. I could be wrong about that, but I
mean, it's not asking me for money, so it looks like you can open them and print them.
Yeah.
I will post this link in the chat. We will also send out after the webinar a link to the video and that kind of thing that's going to go up on our Facebook page. So I'll include this link when I send out that email. I'm going to go ahead and give you back the screen now.
Okay.
All right. Let's see. How does one find notaries that will do Zoom?
That's a good question. I know the Secretary of State's website does have a find a notary button. Because again, it's the Secretary of State's website that it's the Secretary of State that's the agency that governs notaries. Otherwise, I know lots of times banks have notaries. I don't know if they're doing notarization by Zoom, or banks are open and considered essential. So I don't know. It's kind of however your bank might be handling that. You can always look in the yellow pages of your local phone book, and they usually have notaries listed, and just start calling people and asking if they're doing the video conferencing or how they're handling that. You know, this is also new. I wouldn't be surprised if, obviously the information is not going to be in the yellow pages on who's doing video conferencing, because the yellow pages were certainly printed before this law even passed. So this is also new that I would say people are really still figuring it out. So I would just kind of call around to banks, notaries listed in the yellow pages. You might be able to do like a Google search. I'm not sure if notaries have even set up their advertisements or their Google searches to reflect that yet. But you can always just do a notary search for your county or whatever and start calling people and seeing if people are able to do that. It is the law right now, but it's so new, and there really is, in some ways it's really great, because obviously it allows people to get documents notarized without being close to one another. And certainly people who are at high risk, and really all of us, you know, being close to other people is certainly risky right now. But there is a pretty intense protocol that has to be followed. So I don't want to give people the misimpression that this is super easy or you'll get it done in 30 seconds. I mean, there is a very specific protocol that is set out for the for what has to be done for the notary to do this properly. And there are some extra requirements as far as record keeping that the notaries have to keep and things like that. So in some ways, it's less risky, but in some ways it's actually more complicated than getting things notarized in person. So I know we at Legal Aid are still figuring this out, and I would not be surprised if lots of other notaries in North Carolina are in the same book where they're still in the same boat where they're still wrapping their minds around the protocol and figuring out exactly what they need to do.
Okay, well, that's all the questions that I'm seeing. So I think we are all set. Thank you all for coming. Thank you, Attorney Gregory, for an incredibly informative presentation.
No problem.
And the video will be up on the website on the Legal Aid Facebook page as soon as we finish here. And I will get an email sent out to everyone who signed up through Eventbrite with the video and the forms and the links that we've talked about. So thank you all for coming. Have a great day. Everybody stay safe out there.